Yeah, hi, dear aspirant. Today in our rapid revision series, we are going to see a very important topic, that is Indian judiciary. Now, when we talk about the Indian judiciary, first of all, we are going to see the constitutional philosophy. Indian judiciary has been designed to reconcile three constitutional imperatives. The very first is the parliamentary democracy, which is the British influence over India. Second, the judicial review, which is the American influence over India. And it has a vision of socio-economic transformation, which has its inspiration from the directive principle of state policy. Now, when we talk about the judicial structure, it focuses on maintaining the federal spirit of the country, and at the same time, it acts as the ultimate constitutional interpreter. But unlike the British model, the constitution in India is the supreme, not the parliament. So the judiciary is having an effective checks and balance in India. When we talk about the architecture of the judicial system in India, it is an integrated judicial system. Means it is a pyramidal shape. On the top, you would be having the Supreme Court. Thereafter, you would be having 25 high courts in 28 different states in India. And thereafter, we have the district judiciary, and below the district judiciary we have subordinate civil and criminal court. Now, the key implications. When we talk about this integrated judicial architecture, it provides a uniform interpretation of law all across the length and breadth of the country. Apart from this, this 25 high court structure would help to have an effective superintendence over the subordinate and the district court as envisaged under Article 227. This is different from the US dual system, where the federal and the state or the province's judicial system in USA, they work differently. Then the constitutional status of the Supreme Court. Article 124 to 147 forms the core constitutional code of our Supreme Court. When we talk about the Article 124, it talks about the establishment and composition of the apex court, that is the Supreme Court. Article 125, it talks about the salaries of the Supreme Court, High Court judges. Article 126, it talks about acting Chief Justice of India. 127, it talks about ad hoc judges. 129, it talks about Supreme Court and High Court as a court of record. 137, it talks about the original jurisdiction of Supreme Court. Article 137, it talks about the judicial review power. Article 142, it gives the ultimate power to the Supreme Court. Now, when we talk about Article 129, regarding that, large number of questions have got asked. So, the Supreme Court is a court of record. What does it mean? It means whatever the judgment have been given by the Supreme Court, it becomes precedent. At the same time, it has the power to punish for the contempt. Means those people who are not following their judgment, they would be given the contempt as well. Now, when we talk about the contempt, there are two different type of contempt: civil contempt and criminal contempt. Criminal contempt means those kind of act which tries to scandalize the court, or which having an intention of obstructing the justice. Thereafter, please remember regarding the doctrine of precedent enshrined under Article 141 indirectly. What does it mean? It means the law which is declared by the Supreme Court, it shall be binding on all the courts, be it High Court, be it District Court, or subordinate court. Now, what are the key implications? It establishes the hierarchical judicial discipline. At the same time, it ensures uniformity of the legal interpretation. It might happen, if this article would not have happened, then the various court might have interpreted in a very different manner. Okay, that you need to remember. At the same time, this particular article, it gives power to the Supreme Court to override its previous judgment, like what we have seen with respect to Golaknath, overridden in Keshwanath Bharti case, or ADM Jabalpur, which has got overridden later. Thereafter, Article 142, it gives ultimate power to do complete justice to the Supreme Court of India. Article 142 empowers the Supreme Court to pass any judgment necessary to do the complete justice. So, that is a very unique feature, and it provides extraordinary constitutional power to the Supreme Court of India. Some examples related with it are Environmental Governance Order under MC Mehta case or TN Godavarman case, appointment of the SITs, then monitoring the criminal investigation. Likewise, Thereafter, when we talk about the jurisdiction or the jurisdictional metrics of the Supreme Court, again it's very important. In large number of time, the questions have got asked related with it. Like Article 131. Article 131, it talks about the original jurisdiction of the Supreme Court, wherein the Supreme Court has an exclusive jurisdiction to resolve the federal disputes, like the disputes between the center and the state, state versus state. But please remember, this particular jurisdiction is not applicable when the dispute has arisen out of private law related contract. Means it is exclusively only with respect to the government law and the entities like center, state likewise. Thereafter, Article 32, it's very important fundamental right. It provides the citizen of India right to approach Supreme Court directly with respect to violation of fundamental rights. So we have five different types of writs under it, like habeas corpus, mandamus, quo warranto, certiorari, prohibition. But the important thing which you need to remember, that largely the Supreme Court avoids the people to directly approach it. As a first court of appeal, they used to nudge the petitioner to go to the High Court. Thereafter, in this particular rhythm, we are going to see the appellate mechanism, which have been enshrined between Article 132 to 136. Article 132, it talks about the substantial question of constitutional interpretation. Okay, so the court, they used to interpret it. Like under Article 133, they used to interpret the civil appeal. Under Article 134, they used to interpret the criminal appeal. Article 136, it gives extraordinary power to the Supreme Court with respect to the SLP, special leave petition. In this special leave petition, any kind of decree which have been given by lower judiciary or tribunal, that can be overridden instantly by the Supreme Court. Then Article 137, it gives the judicial review power to the Supreme Court of India. Article 143, it gives power to the President, that President may refer any question of constitutional importance to the Supreme Court for their suggestion. Article 143, subclause 1, it talks about the general advisory reference on the part of President of India. While Article 143, subclause 2, it talks about power given to the President of India to seek the advice from the Supreme Court with respect to the pre-constitutional treaty. With respect to the pre-constitutional treaty, the Supreme Court is not binded to give his suggestion. They may or they may not give the suggestion. Then when we talk about the judicial review power of the Supreme Court, it has its inspiration from the various articles under the Indian Constitution, like Article 13, Article 32, Article 226, Article 131 regarding the federal dispute, Article 136 and Article 137. Thus, judicial review is structurally embedded in different parts and articles of Indian Constitution. Thereafter, the important principle which you need to remember is doctrine of basic structure, which has been emerged from Keshwanand Bharti versus State of Kerala case of 1973. What is the principle behind it? The Supreme Court had said very categorically that Parliament may amend any part of the Constitution as per spirit of Article 368, but they can't amend the basic structure doctrine. Examples of the basic structure elements are constitutional supremacy, judicial review, quasi-federalism, secularism, positive secularism in India, rule of law, separation of power, parliamentary democracy, that is Westminster form of governance. So, post 1973, this doctrine has transformed India into a limited amending constitutional system. Means, unlike Britain, wherein you have sovereign power given to the parliament, but in India we have a limited amending power. Then, regarding the appointment in the Supreme Court, we do have a collegium system which has its genesis from the first judge case of 1981, which is also known as S.P. Gupta versus Union of India, wherein the Supreme Court had said the executive would be having the primacy with respect to appointment of the Supreme Court judges. Then the second judge case came, wherein the collegium system had got created, consisting of 3 Supreme Court judges, including 1 Chief Justice of India. Therein, the democratization of collegium system had taken place in 1998 during the regime of Mr. K.R. Narayanan as a President of India, in which the collegium system has got democratized, and now It includes one Chief Justice of India and four senior most judges. The Parliament tried to override this collegium system by framing NJC, but later on in 2015, the NJC had been made null and void by the Supreme Court. Now, when we talk about the High Court, it has been envisaged that a single state may have a High Court or more than one state may have a single High Court. For an example, for Punjab and Haryana, you have Punjab and Haryana High Court. Now, what are the powers are there with respect to the High Court? So, obviously, they have the writ jurisdiction. They have a superintendence over the district court under Article 227 and writ jurisdiction under Article 226. However, they have a wider pocket vis-a-vis the Supreme Court. The Supreme Court can only enforce or can only subscribe to the writ related with the violation of fundamental right, but the High Court can listen to other appeals as well under the writ jurisdiction, like property related issues, matrimonial issues, etc. Then the subordinate judiciary have been mentioned under Article 233 to 237 of Indian Constitution. District judiciary, it forms the base of the judicial pyramid architecture in India. When we talk about the appointment of the district judges, the governor, they appoint the district judges in consultation with the High Court, with the respective High Court. So please remember, the control of the subordinate court, it lies with the High Court and not with the executives. And this ensures the principle of judicial independence, what Montesquieu had envisaged in his book Spirit of Law. Then when we talk about the separation of judiciary from the executive, Article 50 under the directive principle of state policy, it envisaged such kind of independence. Now this independence have been implemented through the various kind of laws like BNSS, Criminal Procedure Code, separation of executive magistrate from the judicial magistrate, which happened in around 1972. That you need to remember. Apart from this, there are certain constitutional doctrines. With the passage of time, the judiciary has evolved. Again, many times the UPSC has to ask the question regarding that. Like we have a doctrine of eclipse. What does it say? That all the pre-constitutional laws which are inconsistent with the fundamental rights, they become dormant. That is the doctrine of eclipse. Then you have a doctrine of severability, which had also got used in the Aadhaar judgment of 2017, which says only the unconstitutional portion of a law can be struck down. Then, the Golaknath case of 1967 brought in the prospective overruling doctrine, means the laws would be applied only to the future cases. Then, the doctrine of colorable legislation. What does it say? It says the legislature cannot do directly what it cannot do indirectly. Okay. So, means the thing is that just by changing the phrase wordings of the law, they can't bring metamorphized form of the law once it has been struck down by the parliament in the previous instant. Now, what are the key issues which the judiciaries are facing? They do have a huge number of judicial backlog. Tribunalization of justice, we can see. Opaqueness with respect to appointment via the collegium system, huge nepotism and all. Lowest judge population ratio globally. We do have only 34 judges for the Supreme Court. We do have only overall 1,106 position for High Court judges across 25 states in India, out of which across 25 High Courts in India, out of which only around 790 vacancies have been filled up. Still around 300 vacancies have still not been filled up. So when we talk about the Indian judicial architecture, largely it has been a foundational spirit with respect to maintaining the independence and the federal architecture in India. Thank you so much.